Lewis is a dear friend of the Pulse. He has been an advocate and a partner for us over the last many years. Lewis is a partner at the Reston Law Group. He brings almost 20 years of legal experience in the government contracting space, particularly on contract litigation matters like pre and post award bid protests. So if you have questions about bid protests, Lewis is the guy you want to know. He has all the answers. At least I'm going to pretend he has all the answers. He can correct me if that's not right. He's done size protests, SBA matters. And my favorite thing about Lewis is a former Marine. You're never an ex-Marine, only a former Marine. So he is in my Marine family as well. Lewis, we are so thrilled to have you. Apologies for making you go through the rigmarole twice. Here's two when folks can actually hear you. But with that, I will turn it over to you.
All right. Hey, thank you, Amanda. And again, no problem. I got to warm up. That's all, was a mic check. All right. So we're going to talk about bid protests because they're basically part of the procurement cycle anymore. If your bid is above a certain dollar figure, you can just plan on there being a protest, planning a protest at the end, whether it by you or by somebody protesting your award. And as Amanda pointed out, CIO-SP4, I've been involved in every round of the protests out there. And that's probably been one of the most poorly run procurements in the history of federal contracting. So if no one heard of a protest before that, they definitely are tracking it now. Now, the people who've benefited the most from that, I think, are CIO-SP3 contract holders, because I think that's going to end up being a 20-year contract. But yes, protests are endemic across the industry these days. Next slide, please. So when you hear the term bid protest, like what is a bid protest, right? In layman's terms, it is a challenge to any procurement decision by the government. All right, it doesn't have to be just an award decision. I think most people know when I win an award or when I lose an award, I can protest and I can go to GAO, and that covers probably 75 to 85% of protests. But there's a lot more that can be protested, all the way from a decision to set a contract aside or not set it aside, a decision to the language in a solicitation at all. We're going to talk about pre-award protests. I will jump up and down when I talk about those, because too many times I dealt with clients who've waived protest arguments. And there's other decisions. One of the current active protests I have right now is a challenge to a task order award. My client had a contract for an agency providing services contract. The agency decided, for consolidation purposes, they're going to not pick up my client's option year, and they're going to put the work under a task order under a pre-existing contract. We challenged that under a bid protest, saying it was a task order, was out of scope of the base contract. And I've been through a round of briefings and had an oral argument on that issue at the Court of Federal Claims last week. So again, just because someone says, hey, I'm going to add this as a task order to an existing IDIQ, doesn't mean that it can't be challenged. And that's an example there. My client was working at location A. There was an IDIQ contract at location B. The agency said, hey, we're going to roll A's work, location A's work under B. And I challenged it as because the location is, 6 states and several hours away, it was outside of the scope of the original contract. And look out, if I win, there'll be a press release and I'll brag on LinkedIn. So you can look to see that.
Lewis, before you move on, I have a hand raised. So Casey, I'm going to go ahead and unmute you if you'd like to ask your question. I guess you should get, there we go.
Sorry, I did not realize my hand was raised. My apologies.
Oh, no problem at all. All right, Lewis, carry on.
All right, next slide, please. Okay, so the biggest issue with bid protests is your timeline. If you're talking about a GAO protest, your timelines are very, very tight and they're very draconian. All right. So if you miss a GAO timeline, you will be dismissed and you won't be able to move forward. All right. There's You could recover and go to the Court of Federal Claims and other options. Maybe that becomes much more expensive. So if there is when you're talking GAO, in order to file a bid protest and have it timely, it has to be filed within 10 days of when you know of your ground of protest. This gets more complicated because there's also a automatic stay when you go to GAO. But in order to get your automatic stay, you have to file within 5 days of when you know of your protest. So you could file a timely protest and not get an automatic stop work order that goes along with it. So it's really important if you think if you even have wind of the fact that you might have a protest or a protest argument, you need to talk to an attorney right away to make sure you don't accidentally waive your ability to protest. And pre-award protests have to be filed before the bids are due. So if your bids if your bids are due at 12 p.m. on Friday, your protest has to be filed by 11:59 a.m. on Friday morning at GAO in order to be timely. So a question from David talking about the shutdown. The shutdown will not impact any actual filing deadlines. The GAO deadlines are regulatory, which means they are not waiverable. They don't change. If you don't meet them, it's a matter of a law. Obviously, you're going to see things happening because GAO might not be acting on a protest that's filed, but the GAO, as far as the deadline, if you have a notice that you have a contract or a protest ground, you have to file it within the 10-day period. The shutdown isn't going to impact that. I'm holding my breath and crossing my fingers that our politicians actually do their job between now and Friday, since I think about 95% of my clients are government contractors. I wish I could be as bad at my job as Congress is at theirs and then keep my job. But I'm not picking on any one particular party. I think they're all terrible. That's my stance. So, next slide, please. All right. So the other big question is, where am I going to protest? And there are three potential options. You can go to all three of them from day one, and you can also move from one to the other as you go along. So that makes this clear as mud, of course. The first thing you can do is you can go to the agency. If it's a VA bid and you don't like what they did, you can protest you can file an agency level protest and by definition, under the regs, the agency level protests go to a contracting officer, which, you're like, well, I'm going to go protest to the same person who made the decision that I am protesting. That is generally why I don't use agency level protests. Now, on the flip side, there are times when you want to go to an agency. There was one a couple years ago I had where the agency picked a company to give them an award, and the company had an $800 million adverse judgment against it, which means the company was teetering on bankruptcy and on its way there. I filed an agency level protest, basically not to embarrass the agency in front of GAO because they should have known that. And that's probably the most successful agency protest ever, because the contract award was rescinded, I think, within 24 hours. But there are certain agency bodies, when you look at a contract, they will talk. There's some sub agencies within the Army that have a specific panel that reviews agency level protests. And in that case, you may want to, it might be more worthwhile to go to the agency than going to GAO right off the bat. But that language, you generally will look, it'll be in the RFP and it'll talk about agency level protests in there. Now, when you go to the agency, again, you do get an automatic stay while they can't award the contract and move on while the protest is going. In the past, I've used quotes saying that agency protests are generally worth the value of the paper they're printed on. I might have moved a little bit off that needle, but I would say 95% of the time, I'm not going to the agency on a protest level. The good news on an agency protest is because it doesn't involve a protective order and it doesn't involve proprietary material, you can honestly do an agency level protest on your own. You can file one without an attorney, and it may make your costs a little bit lower if it's a small contract, and the dollar figures don't justify the cost maybe of protesting a GAO. You can at least have someone take a second look at the issue at the agency, and you can do it pretty cheaply. The next option, and the most common option, is GAO, Government Accountability Office. This is the most common because if you're going to involve a lawyer and you're going to do a bid protest, this is the cheapest and fastest forum to do it. By regulation, GAO protests have to be resolved within 100 days. So if you file a protest today, you can mark your calendar that in 100 days from now, it will be resolved. When you go to GAO, you automatically get a stay as long as you file within 5 days. It's called a CICA stay. CICA, CICA, stands for the Competition and Contracting Act. So when you file a protest and it's done timely, the government cannot move forward with the award. All right. This is the reason why so many incumbents protest. All right. And it becomes a business decision at some point. If you lose an award and you're the incumbent, I can protest for X dollars. I'll get 3 extra months of work and I'll make Y dollars in profit. So a lot of companies will make a decision to protest just because of that on the finances. It's a little frustrating sometimes. I try to discourage my clients if I don't think they have a good protest ground. I try to talk them out of that. But at some point in time, business is business, and that's how the stay process factors into that decision. There are certain types of contracts that can only be protested at GAO, and these are task order contracts. So if you have a task order under an IDIQ, you can't go to the Court of Federal Claims. You have to go to GAO. So that's another reason. And as the government spends more and more and more money through IDIQs, that's another reason why more and more protests go through GAO instead of the court. The Court of Federal Claims is a real court with a judge behind a bench wearing a black robe and having a hammer. And there's no jury in there, but you show up and it looks like a court that you would see on TV. Now the beauty of the Court of Federal Claims is you don't have the same aggressive timelines you have at GAO. So if you do miss a GAO filing deadline and your contract is not a task order, you can go to Court of Federal Claims 2 or 3 weeks after the fact. Now, if you try to go to the Court of Federal Claims 2 or 3 months after the fact, the court could dismiss you as untimely. There's no hard and fast regulatory rules at the Court of Federal Claims. You just have to be diligent in pursuing your rights. Now, the court is a court, so it's a lot more expensive. You have the pleadings are more robust. There's more pleadings and arguments that need to be made. There's an actual oral argument as part of the process. So it's probably at least double, if not triple, the expense of GAO. Lately, I've been steering more clients to the Court of Federal Claims. I've been pretty disappointed with some of the outcomes out of GAO of late. And I don't know if because there's so many protests. I don't know if there's a lot of new GAO attorneys, but I've had some protests at GAO where I've lost, and I honestly believe that 2 or 3 or 4 years ago I might have won those protests. So I brought a couple straight to the Court of Federal Claims. If it's a bit of a novel or complicated or different argument I'm making, a lot of times I'll go to the Court of Federal Claims as well. The task order out of scope issue is one of them. So I brought that to the court because that's not a standard GAO protest. So sometimes it's worth the extra money because the Court of Federal Claims is less overwhelmed and less busy than GAO. So they can take a little bit more of a deeper dive into a protest. Now, you don't appeal a bid protest decision. But if you lose at GAO, you can then subsequently turn around and file a protest at the Court of Federal Claims. If you lose at the agency, you can then turn around and file a protest at GAO. In legal terms, it's a de novo review. De novo is Latin for something like brand new. So they look at it from scratch. You're not challenging. If you file an agency protest and the agency rules against you, you don't go GAO and say the agency's protest decision was wrong. You go back and start all over again with your arguments from the beginning, and you get a fresh look at everything at GAO. The way it works as a timeliness decision is you're protesting the agency's final action, which was rejecting your protest at the agency. And the same thing at GAO, GAO to the court, it gets a little bit legally different. You're challenging the agency's decision to follow GAO's recommendation. GAO, for those of you, here's a bit of trivia for you next time you talk to a protest lawyer. GAO does not order an agency to do anything. GAO does not have the authority to order an agency to do anything. GAO highly recommends that an agency does X. GAO reports directly to Congress, who funds agencies. So agencies 99.99% of the time will follow GAO's recommendation. So you can then go to the Court of Federal Claims and say that the agency is being arbitrary and capricious because they're following GAO's recommendation that is incorrect and wrong. So that's the way you get into the court at that time. But again, on the screen here is the timeline of a GAO protest. So that's that shows you where it goes. And bid protests, actually, I'll since Amanda gave my full background, bid protests are like combat. They're periods of intense action followed by long periods of absolutely nothing and boredom. So when you have to first get your protest in and you're rushing to make your seek a stay deadline or your protest deadline, you're scrambling and writing. And I've written a lot of protests on weekends and late at night to make deadlines, because sometimes some of my lovely clients wait until day 3 to come tell me they want to protest. And then I have 48 hours to get my protest filed. Then you wait 30 days for the agency to produce your record. And then once you get the record, you have 10 days to file your comments on the record. And then you sit around for a couple months waiting for GAO to issue a ruling. So it gets really intense for a few days, and then you twiddle your thumbs waiting for GAO to make a decision. So again, the takeaway from here is you have several options on where to take your protests. There's plus and minuses on all of them. Some of them are business decisions that relate to costs. Some of them are you only have one forum because of the type of contract. And some of them are, well, I can only go to the Court of Federal Claims because I waited too long. So the repeated thread and the repeated commonality in a bid protests webinar is call your attorney as soon as you think there's an issue. The sooner you get your lawyer involved, the sooner you make sure you don't miss a deadline. And I can write a better bid protest if I have 5 days than if I have 2. So, I can turn it around in 2 days, but generally you're going to get a better quality product if I have 4 or 5 days to think about it. Next slide, please.
Lewis, before we move on, I have a question for you. This is grounded in my extensive legal education through 7 seasons of The Good Wife. If you take an issue to the Court of Federal Claims and a decision is made on something new, like this task order issue that you brought up, can that then be used as legal precedent in future filings dealing with similar issues?
Yes, so a court is a court, and actually GAO is the same way, right? When you bring any, whether it's a controlling legal precedent, GAO is not necessarily controlling legal precedent, but if GAO rules A today, they're most likely going to rule A tomorrow and next week and next year. So you cite back to those in the court. It does become binding legal precedent. And the other option too, you rarely see this in the bid protest realm, but if you are at the Court of Federal Claims, you then can appeal up to the federal circuit after the fact. You're rarely going to see it because there's very rarely, most bid protests hinge very much on the facts, not the law. And very rarely are you going to appeal a factual decision. But yes, a Court of Federal Claims opinion is precedential for future opinions. And that's actually what's made my current one on the task order award kind of interesting, is there's not a lot of published opinions out there on what is an out of scope task order award. is a new geography enough to be out of scope? And the court hasn't squarely answered that question. So whether I win or lose this protest, I'm going to get a published opinion that's going to be precedential going forward on that question. Which, if you're a legal dork, that's kind of fun.
See, folks,
So-
here at the Pulse, we don't just bring you subject matter experts. We bring you trailblazers in their field. All right,
So,
Lewis, carry on.
trying.
Thank you for that.
So, okay. All right. So this gets to the grounds of what can I protest? All right. And pre-award protests, again, I spent 7 years as an in-house counsel with some government contractors, and I would read every RFP that we were getting ready to bid on. And the reason I read the RFPs is not because I knew crap about the technical stuff and the technical solutions. I would read them to make sure that the RFP did not have any issues or problems with it. A lot of times you see when you go and read your evaluation criteria, sometimes it doesn't make sense. The government is like everyone else, right? No one writes an original document anymore. We all take out something we wrote in the past and we cut and copy. And a lot of times when the government's doing that with an RFP, they might leave in language from the old one and they might miss to take it out. Right. So those are the types of things that become a problem. And here's a perfect example. My colleague was on the phone with a client today. There's an RFP there. They just extended the due date of the RFP from October 2nd to October 16th. But the RFP still says that PPQs must be submitted by October 2nd. Right. This is now a question and ambiguity. So the client said, well, if the agency doesn't answer and clarify, we're going to need you to protest because it doesn't make sense. If everything's due on the 16th, everything should be due on the 16th. So that's one. A lot of times your evaluation standards could be wonky. Those are, and a lot of times the agency would never wire an RFP for a specific offer. But a lot of times the agency writes an RFP that maybe only one person really can bid on. And that's kind of a bundling thing, right? If I say, I want to buy IT help desk services, but while I'm at it, I also want to buy branded shirts, right? Because I want my help desk people to have branded shirts on, right? That's an improper bundling. They're not related. If I wanted to buy servers and I wanted to buy the services to install the servers, that makes sense. So those are the kind of things you want to look at. Now ambiguities are important because there are two types of ambiguities in protest law. There's a patent ambiguity and there's a latent ambiguity. If it's a patent ambiguity, you have to protest it before the bids are due. Patent ambiguity would be like if I have one section of my SOW that says I only want Dell servers and I have another one that says I only want IBM servers, that's a patent ambiguity. All right. You have to challenge that ahead of time. A latent ambiguity would be where I ask for something and, I say I need a car. And then when I evaluate you, I say, well, when I said I wanted a car, I really meant I wanted a Jeep. Right. That's a latent ambiguity. And you can come back after the fact and say, well, I didn't understand. And I believe that car could have been a sedan. So that's a latent ambiguity. You got to clarify the RFP and I get to rebid. Those things have, but like I said, the patent ambiguities have to be protested before award. Pre-awards, again, and what I always tell clients, when you guys know your industry, when you read an RFP, if something in the RFP doesn't make sense, you should talk to an attorney about it and figure out if you need to file a pre-award protest. What I normally do in a pre-award protest is I will first send an email to the contracting officer. And it's surprising. You can email the contracting officer 50 times complaining about something. The minute I send the same email and I tell him if he doesn't fix it, I'm going to file a pre-award protest. And mine says, Lewis Rhodes Esquire, they will respond to me most of the time. So normally you can get this fixed with an email without having to go into a protest. But again, I pound the table on pre-award protests because I've had a lot of clients come to me. They have a legitimate protest ground and they missed their opportunity because they didn't protest it pre-award. Mid-procurement challenges, that's if you get kicked out of a competitive range, right? You can ask for a debrief and file a protest at that point in time. The agency can push it back to final award, but you still need to get your debrief request in at that point in time. That's generally the mid-procurement stuff. Post award, right? It's generally the agency didn't evaluate me fairly. That's the most common one. The agency did not follow the terms of the solicitation. If the solicitation says technical is way more important in price, but you win technical by a lot, and the other guy gets the award when he's only a little bit cheaper, you challenge how the agency applied the evaluation. There's a whole ton of protest grounds. I'm not going to go into them there, but basically once the award comes out and you get your debrief, and what I tell clients, and I think I have this again later on, you spend so much time and so much money putting a solicitation and answering a solicitation and putting a proposal together that you really want to make sure you get treated fairly. Run your debrief questions past an attorney or the response, just so you can get a sanity check on whether or not you have a legitimate protest ground. A good attorney, and I call myself a good attorney, I will honestly tell my client if they'd be wasting time and money with a protest. But you want to make sure you get treated fairly. And I know I'm talking a lot and I'm probably running out of time. So I'll start. You can just tell me to speed it up as need be.
No, this is great, Lewis. Keep going.
Yes. Okay. So what should I do when I protest? All right. When you get a notice of an unsuccessful award, you should always, you should reply to that email with, "Thank you for letting me know. Can I please have a debrief?" Right? You always get a debrief, especially if it's under part 16. It's a negotiated contract procurement. Now, if it's a FAR Part 8, it's not a debrief, it's an explanation of award. This becomes important because it impacts your protest deadlines. But the first thing you should do is request a debrief. The second thing you should do is run it by your attorney, be it inside or outside counsel. You're allowed to ask questions during a debrief. And if you get to ask questions, if you come to me, I will tell you certain questions to ask, because this is a way to maybe start discovery for our protest letter. We don't get discovery in bid protest rules, but if you can get the government to tell you certain things and answer certain questions, it would help us as we craft a potential protest. And I'll also tell you questions to ask, because maybe you just got beat and maybe you shouldn't protest. And I always get frustrated with agencies, because a lot of times the government has this belief that the less information they give you, the less likely you are to protest. And I always tell the government it's the exact opposite. The less information you give and offer, the more likely they're going to think you're hiding something, and the more likely we're going to protest. So whenever you talk to a contracting officer, you should always tell them, if you give me more info on a debrief, I'm less likely to think you're hiding something from me. So now also on a debrief, you're allowed to have counsel present on a debrief. If you think the agency really did something wrong, you just have to tell them ahead of time, because if you show up with your lawyer, they have to bring their lawyer. So, but if you have a lawyer and you say, I want you to listen to this debrief, you can do that. You just need to let the agency know that your counsel is attending. When I was in-house, I would sit in on almost every debrief, because there's certain things I've been trained to listen for. If you're a DOD a couple years ago instituted enhanced debriefing procedures. These are important because, again, these impact your bid protest timelines. And it's actually really good. And if the agency is diligent and the agency is doing its job, they're supposed to give you more information to help give you more feedback and to help avoid a protest. After you receive your debrief, you have 2 business days to submit a list of questions to the agency as follow-up questions to your debrief. And one of my clients just submitted some yesterday morning. That sub-agency told them they were limited to 10. I hadn't seen that before. There's no real basis for limiting them to 10. But again, you get to say, all right, here's my series of questions that I have as a follow-up. The agency is supposed to answer you within another 2 days. They can take longer than that. But here's the really important issue this. Your debrief is not deemed closed until you get your responses to your enhanced debrief questions. So if I submit my client submitted enhanced debrief questions yesterday, when they get the written responses from the government, that's when our protest clock starts, not when the actual verbal debrief happened. So if the government responds to the written questions today, our protest clock starts today. If they respond tomorrow, it starts tomorrow. I hope they respond Friday, because that means our protest clock starts Friday, and I'll have till Tuesday to file the protest next week, and I won't have to spend most of my weekend writing a protest letter. But so the enhanced debriefing procedures, they're a couple years old, but in GovCon speak, that's brand new. A lot of people are still figuring them out. There was a really high profile case a couple of years ago that the agency had a protest. The protester submitted questions. The agency answered questions and closed the debrief. The offerer asked more questions, and then the agency answered those questions. And then the offerer protested based off of the second set of answers. But because the agency said your debrief is closed after the first set of questions, even though it answered the second set of questions, the protest clock started running when the agency closed the debrief. So again, this is a process where it sounds trivial, but when a debrief is closed, is going to impact your timeline. Because again, if you miss your GAO deadline, you can't waive it. And if you miss it and it's a task order, you can't protest now. So very close attention. What I tell people all the time, and it's not because I'm upselling my profession, your protest attorneys do this for a living. We know all the deadlines. We know what the rules are. It gets really complicated. And what's a SECA stay? What's a protest deadline? How do I, when does my protest close? You don't have to remember all of that. Just remember to pick up the phone and call your attorney. They will know all of that. And I like my clients to talk to me before they do their enhanced debrief, at least, because I help write the questions. And I say, okay, ask this, ask this, ask this. I know what the government's not going to answer. And I can try to help write a question in a way that the government is going to answer it. So, the foot stomper here is you really need an attorney and you should talk to one. Okay. And actually, one thing I forgot to put in my slide deck when I was putting it together, and I mentioned it earlier. You really need an attorney to protest for you, unless you're at the agency. In the protest, you're going to get the protest record. The protest record is going to include all the offeror's proposals. If you're the protester, you're not going to be able to see your competitor's proposals. So I'm going to see every document that impacted the government's decision-making process, and it's under a protective order. I can't tell my clients everything that I see in the file. I've been doing this long enough to know I know what I can tell my clients, and I can deliver a message without violating the protective order. But I can't share everything I've read. Everything gets redacted because there's a lot of highly proprietary information. I am going to know what your competitors bid for pricing, right? So if you don't have an attorney, you don't see any of that stuff. You don't understand what strengths and weaknesses your competitors got evaluated with. Only an attorney who's an outside counsel. When I was an in-house counsel, I couldn't do bid protests for my company because I couldn't get under a protective order. So you're basically completely ineffective, and you'd be shooting blindly if you tried to protest without counsel. Now, if it's a pre-award protest, you could probably protest without an attorney because there's not going to be any protected material. But if you're doing a post-award protest, not only should you use an attorney for the process, I could probably stitch my arm closed if I cut myself, but I'd probably be better off to go to the hospital and have the doctor do it the right way. Just because you can walk through the process doesn't mean you're going to do it correctly. So, that's the other issue on why you really need a counsel. Now, Probably the most common question I get when I talk to someone about a protest, like, isn't the government going to get mad? Isn't the agency going to get mad at me when I protest? And my answer right now is 99% of the time, absolutely not. It's part of the procurement cycle. It's become even in the last 15 years since I've been doing protest work, it's baked into it. If you see the government build their timelines when they do all the way up, when they're doing their pre-procurement work, they put 100 days for a protest on the backside of their timeline. They just assume that's going to happen. The government knows it's part and parcel. They know companies spend a lot of money. They know it's highly competitive. They jump up and down, like they don't get angry. Now, if you got rated really badly, you submitted a bad proposal, and your pricing was really high, and you file a protest just because you're the incumbent and you're trying to steal 3 extra months of work, that could piss your customer off. If you go in and accuse the government of doing a lot of nefarious and bad faith things, that could piss your customer off. But just in general, if you have a good faith protest argument, you don't feel the government did something right, it's not personal, it's just business, and they're used to it. And the other thing I tell, especially if you're talking about a really big opportunity, offers spend hundreds of hours and thousands, if not tens of thousands of dollars putting a proposal together. Your protest is going to be a fraction of the cost of doing that. I can put a protest letter together probably and get all the way through the record and review the record for 10 to 15 hours. So you're talking, even if it's a complicated protest letter, you're probably talking under $10,000 to file a protest. If you spent $70,000 or $80,000 putting a proposal together, spending an extra $5,000 to $10,000 to make sure you were evaluated fairly, is the investment. What I tell clients is, if you're considering a protest, like when you're considering a solicitation opportunity, build the protest cost into part of your budget. And yes, David, great comment. If I win your protest and you win the contract award on recompete, obviously, that's absolutely worth it. Now, and the other issue is if you win a protest, you can get some of your attorney's fees. Refunded. There's this EAJA, Equal Access to Justice Act, where agencies, if they fight a protest and lose, you can file a petition to get reimbursed for fees. And while they won't pay every penny of your fees, you'll get a good chunk of them back. So not only do you win your protest, you also can get some of your money back. And okay, yes, I was about to ask if we left the awardee slide in here. Now, what happens when you win and you get an email that says, I'm notifying you have to stop work. There's been a protest against your award. You can intervene, and you have a legal right as the awardee to intervene. You want to intervene to help the government defend your award. Agency counsel are like lawyers and people in any profession. Some are really, really good. Some are not as good. I've helped. Sometimes agency counsel are absolutely buried under a whole bunch of things. If it's your award and you want to make sure you keep it, if you hire me to help you intervene, I can help the agency do legal research. I can help the agency write briefs. I can review some of the agency's briefs before they're filed at GAO. So you definitely you always want to intervene. If for no other reason, I sit back at 50,000 feet and I watch the government and make sure the government doesn't mess up in the process. And yes, that's a good stat on success rate for GAO protests. Now, that success rate includes corrective action. What the government likes to talk about is, only 20% of protests are actually win on the merits. And that's absolutely true, because most of the time when the government sees a successful protest argument, they take corrective action. I've had corrective action taken 4 times in the last 2 months in protests, where the government's going back and doing a reevaluation because they realize they screwed something up. So that is a win, because that means, you're getting it, they're taking another look at you. So again, protests are part of the process anymore. Unfortunately, you do not, if the protest fails and you're the intervener, you do not get your attorney's fees reimbursed. You get to win the contract and keep your contract. So the government thinks that's all you get. Now, I've had interventions where I think I might have put in 2 hours of work. And I've had interventions where I've put in 25 hours of work. So it's really hard to say. What I tell my clients is, if I have to do a lot of work as an intervener, you're going to be happy I did, because that means the government's not doing a very good job in defending the protest. So ideally, I put in 2, 3, 4 hours, and you keep your contract award. It's all about understanding scope when you do something like this. And I think lessons learned, last ones. I love all the Schitt's Creek memes on here and GIFs. Best show ever.
Both are big Schitt's Creek fans.
Yes. Be proactive. Talk to your attorney right away. Don't waive any of your rights. Okay. A 5-minute phone call is worth it to make sure you don't miss a deadline. Getting your attorney involved early and often, RFP stage if something looks funky. As soon as you find out about a unsuccessful offer notice, reach out right away. The more prep time I have, the sooner we can make sure that we're going to get a really good successful protest in. And again, level set your expectations by knowing a protest is going to happen, whether it be you or by somebody else. Just because your contract is awarded today, don't start banking on your revenue next month. Like, don't go out and buy your new car based on your new contract. Understand it's going to be 3.5 months before you actually start doing work. And I think that is our last substantive slide. Woo!
It is. So if you need to take a drink, take a breath. I know, folks, we're approaching 12 o'clock, so you may need to drop. That's totally fine. As I mentioned earlier, if you are a member, this full recording will be available in the next couple of days. If you're not a member, please shoot us an email and we can help you become a member. So with that, I will open it up. Do folks have questions? Haley, any questions you have? Anyone else on my team? We have Lewis. He is an expert. I have learned more in the last 45 minutes probably than I have in a semester of my doctoral program. So this has been fabulous. We're so happy to have you and want to make sure we get as much information out of you as we can while you're here.
Yes, agreed. Thank you, Lewis. You answered all my questions before I had a chance to even ask them. So much appreciated. And I think this is definitely going to go down as one of my favorite lunch and learns.
Oh, thank you. And the last plug I'll put in, I don't know if you have my contact info on your slide deck in there. I don't charge for a consultation. So if something weird happened and you think you may have a protest ground and you don't have an attorney, if you call me and it's a 5 to 10 minute conversation and there's no protest, I'm going to talk to you about it, and we'll make sure you're taken care of, and I'm not going to bill you for a 5-minute conversation. In fact, my existing clients, I have some clients who've learned my schedule well enough to know when to call me when I'm in the car. Because if I take a call while I'm driving from point A to point B, I don't bill for it. So I'm probably one of the I think I failed that class in law school on how to bill all my time accurately. So, but in all seriousness, I like to help my clients. I work with a lot of small businesses. I love representing, especially other veteran-owned companies. I want clients who are going to be my clients in 5 years and 10 years, and I'm not going to do that by nickel and diming them. So, you ever have a small question, feel free to pick up the phone and give me a call. I'll add a disclaimer in there that, it's not necessarily legal advice. But I'll give you an idea if you have a protest ground, and so don't sleep on your rights. Don't miss it. The government messes up a lot. They do a lot of stuff. They do it very fast. Like most people, they're overworked and underpaid, and they make mistakes. And when you're spending as much money as you are to bid, and it's so competitive, you want to make sure you get treated properly. So that's how you should look at your protests.
We'll add
And
that,
ladies, this was fun.